Good afternoon, welcome to our live webinar on family law. I trust you are all well and having a lovely day, and hope you are looking forward to the weekend and you will be safe. Nonetheless, today's topic, family law, general family law Q&A with myself, Advocate Mohammed Abduroaf. There's three questions that were posed and I shall deal with them. First one deals with child maintenance, basically a deduction for child maintenance. Second one deals with care and contact. What can you do even if you never saw your child for some time? And third one deals with relocation consent issues. Those are topics which our webinar generally deals with, and every time when I answer a question you get a different angle and a different spin on it. So should you deal with your own legal problem, you would have a bit more insight into how to deal with these specific issues and problems. Question number one. I lost my job and I cannot afford to pay the full amount of maintenance. What are my options? Interesting question, but a valid question, relevant in the sense of people lose their jobs, people get promoted, people start earning less money, and so on. If a maintenance order was granted and you are ordered to pay a certain amount of money and things have changed, you lost your job, whatever the case may be, obviously we now have to relook the maintenance amount. You cannot afford to pay it. It's silly for a court who has made an order for you to pay X amount of money and now you're totally unemployed. You cannot factually afford to pay it. There's no other options available. You only have your salary. I will look at assets shortly. Obviously you cannot be ordered to pay the amount because you won't be able to pay that specific amount. You may take out some debt, but at some point that specific loans would be limited. You cannot take any further credit and so on. Therefore, what does the law expect you to do? Should the courts now come and arrest you for not being able to pay an amount of maintenance despite you being unemployed? Should you go to jail? What's the purpose behind that? What's the use of you going to jail or to prison and not pay any maintenance, because once you are in jail or in prison you cannot earn any money and so on. So nonetheless, let's look into the specific issue. Let's try to unpack it. Now, in terms of South African law, you pay maintenance according to your means. Therefore, means has various facets. One would be your income, your salary, how much money you earn every month by working, going to work, obtaining a salary, commissions, buying and selling things, whatever form of income you have. Means can also be seen as your assets. You own a home, you own a car, you own a cell phone, you own a watch. That's also means as well. You have assets. Someone who earns zero but owns 5 houses, he earns zero per month in the sense of a salary, and he owns 5 houses. He's not renting it out, so there's no income where those houses are concerned. He pays rates and so on. That person can be ordered to pay much more maintenance than someone who earns 20 or 30,000 rand per month. I'm just using 30 figures here. Because that person has more means, he or she can sell a house, can rent out the house and so on to pay the maintenance. Why must a person who earns a salary, works very hard each month, who has no assets, use his income to pay maintenance, which he should or she should do so, but the person who decides not to work but who has lots of assets, lots of wealth, in that sense, not cash but assets, should be paying less maintenance. That would not be fair. Okay, so we dealt with the principle of fairness. If, however, it is concluded that we considered your income, much less income, we looked at your assets, there is not much assets. Of course, you have to have a home. You can't just sell your home or cut your home in half. You need to have a place. So we will contact take place. Your car, you most probably need a car. You can't downgrade. You are struggling there, so you need to have a car. Whatever the facts are, and there could be valid reasons for a reduction. It's very important to note that. Then we also have to relook everything. We have to look at the income and expenditure of the party claiming the maintenance. For argument's sake, in our scenario here, the mother. How much is she earning? What is her contribution, etc. Because we now need to find a workable solution to this specific problem. What is reasonable under the circumstances? Does the specific person have other children, other expenditure as well? We need to relook the whole aspect of the minor child as well. What is the maintenance obligations of this father? What does it entail? Does it entail extramural activities, which is important? Does it entail holiday expenditure? Some luxurious items? Does it entail part of the living expenditure for the minor child, internet, Netflix, etc.? So we need to now tighten the belt a bit. This is a circumstance. A child cannot stipulate that I'm the child and my parents should work super super hard so I can maintain a certain luxurious lifestyle. Care for the minor child. The child should be adequately cared for. But if the parents do not have the necessary means to care for that minor child, then that's unfortunately how it is, and the law needs to consider that. And if it means a child's lifestyle should be downgraded, unfortunately that is the case. If it means a child should go to a different school because the parents do not have the money, it's important for you to note I'm dealing with a scenario where factually the parent cannot afford. There are many scenarios where the parents can afford, um, but they prefer not to. And factors that are considered is, of course, the means. The person has a second job, the person has a smart car, a flashy car, and a flashy house, and so on. And obviously, that person can downgrade there in order for the minor child to maintain a certain standard of living. So, my answer to this specific question is you need to approach the maintenance court and make an application for a reduction. They call it a substitution of a maintenance order, basically stipulating that the old maintenance order should be substituted with a new maintenance order. Therefore, if the current maintenance order stipulates that you should pay 5,000 Rand per month, I'm using a round figure here, and you can only afford 3,000 Rand per month, you're asking the court to substitute the old maintenance order with a new maintenance order of 3,000 Rand per month. If the old maintenance order stipulate, or maybe the current maintenance order, a better term to use, stipulates you must pay school fees, half the school fees, and you no longer can afford to do that, then the new maintenance order, should the court order so, would stipulate that you are no longer responsible to pay school fees because you cannot afford it. Please remember, I'm dealing with fictitious scenarios over here. I'm giving advice to people. I do not know all the circumstances, all the facts, but if there is truly a case for a reduction, obviously the courts will have to be fair and make that specific order. And with the same principle applicable, if a mother who cares for the minor child, she earns less money and she cannot provide the minor child with what she usually provides the minor child with, she has full right to approach the maintenance court and say, I would like to have more maintenance. I want the other parent to pay more maintenance because my income has decreased. The knife cuts both sides. That's how it works. So if you are the mother or the caregiver, or the father and a caregiver, primary caregiver, and a maintenance order is in favor of you, for the other party to pay you the maintenance for your minor child, and you no longer can afford to maintain the child, you lost your job, whatever the case may be, the court can come to your assistance and increase the maintenance, substituted with a higher amount for the other party to pay. Obviously looking at all the factors. That is important to note. And at the same time, if the maintenance order stipulates that you should pay X amount of money, but the other parent now earns a substantial amount of money, became super wealthy, and now when the maintenance order was granted initially, both parties basically had to contribute 50% towards the minor child's expenditure. We looked at everything, the income, expenditure, and so on. But now the parent caring for the minor child became very wealthy, got a big promotion, whatever the facts are, and now he or she only contributes 5% of his or her income towards a minor child. That is a very good reason for the parent who has to pay maintenance to say, no, this is not on. I'm paying 50% towards a minor child expenditure, 50% of my income or my wealth or my assets towards a minor child's expenditure. You, on the other hand, parent, is only spending 5%. It's unfair. Therefore, I should pay less maintenance. My apologies for that. I should pay less maintenance towards a minor child. So that's how it works. I hope you are following the trend. It's about fairness, what's equitable, and so on. But at the same time, we focus on what is best for the minor child. But it's not best for the minor child to have a maintenance order in favor of him or her for an amount which the other parent cannot afford. Things have to be relooked at. So that was question 1. I have some live questions as well, which I shall deal with. I'm acknowledging each one of you, so I will deal with that after I dealt with question 3. So question number 2. The last time I saw my child was when she was 4 years old. She is now 7 years old. Is there anything I can do to have contact now? Interesting question. I'm not going into the merits as to why the party never saw the child for the last 13 years. That's a factual thing. Now you'd like to be introduced into the child's life or reintroduced into the child's life 13 years later. Now, besides looking at the law, we also need to now look at the psychological impact of this reintroduction of yourself as a parent into the minor child's life at the age of 17. That's very important because the law does not only look at your rights. You're a parent, you have rights, or we look at the psychological and emotional well-being of the minor child as well before we start implementing those rights. That's very important to note. We first look at the needs and the well-being of the minor child before we look at the needs and the well-being of parents. Here we have a scenario where this parent wants to come into the minor child's life 13 years later, which I commend the parent for. Whatever happened in the past, that's something which the parties have to resolve between themselves. But now we have a scenario whereby the minor child has a parent who wants to be reintroduced into the minor child's life. The question is that in the minor child's best interest? Of course, holistically it could be. However, how are we introducing the specific parent into the minor child's life at this age of 17 years old, when the minor child might turn 18 in a few weeks' time or in a few months' time? So there's a psychological aspect applicable here. If the minor child at this specific age says, no, I do not want to be reintroduced to my father 13 years later, that's very important to consider that. It's more important to consider it at that specific age of 17 years old as opposed to should the minor child have been 7 or 8 years old. Because the psychological impact it has on a child of 17 years old who may be in high school, maybe matric, maybe not stuck in a certain way, but have a certain type of lifestyle, certain routine, and all of a sudden, here this father, out of 13 years later, wants to come and be involved in a minor child's life. My advice to you is that maybe speak to a social worker who can assist you in this process. The social worker may be able to approach the mother and ask the mother, you know what, I've been approached by the father, and the father would like to have contact with the child. What is your view on that? Somebody that can mediate this issue. And if that does not work, try other potential more subtle means. And if at the end of the day, if that does not work, maybe have an attorney write a letter to the mother and asking the mother, I would like to be introduced into the minor child's life. What does the minor child have to say about that? And if all else fails, then maybe the matter must go to court. But I would consider dealing with this matter very cautiously. If the minor child turns 18 in a month's time, I would most probably advise you do not do anything about it. The child will be an adult in any event in a month's time, and when the matter gets heard, the child's an adult, the whole application will be basically thrown out of the window, because children's court only deals with children of 17 years old and younger. So I hope that assists you. Be very cautious where this is concerned. If the child had to be 4, 5, 6, 7, different story, different scenario. I would have said as soon as possible be reintroduced into the minor child's life. 17 years old, turning 18, but more challenges involved. So that was question number 2. The third question and the last question before dealing with the Facebook Live questions. I want to move my child to another country. I do not know where the father is, but his name is on the birth certificate. What can I do if I cannot obtain his consent? Okay, how does it work? In terms of South African law, both guardians of a minor child has to consent for the minor child to leave the Republic of South Africa. The same applies for an application for a passport. So the mother applies for a passport. They ask, where's the father? His name's on the birth certificate. Problems, challenges. The mother wants to leave the country, Home Affairs will ask where is the father's consent. He's a co-guardian because on the birth certificate. Then the mother says, you know what, this father is not involved in the minor child's life. I never saw him for many years. Maybe she's lying, maybe she's not. We do not know. Then they'll send you to court and or advise you, please get a court order stipulating that we do not require the father's consent for you to relocate or for the passport application and so on. So my advice to you, the specific questioner, is you need to make an application to court first and foremost that you can be provided sole guardianship rights over your child, that in the event you do relocate, the consent of the father will not be required for the relocation, the consent of the father will not be required for the passport application and so on. If you cannot get hold of the father, unfortunately, and you do not know where the father is, he's not on Facebook, he's not on WhatsApp, he is nowhere to be found, you do not know where, his family does not know where he is and so on, then of course you'll have to approach the court for an application for substituted service via newspaper, government cassette and so on, because the court wants to know that you have tried everything possible to advise the father of this application for sole guardianship rights and etc. But when this application ultimately gets heard, be smart about it. Your legal representatives must ensure that the order is all-encompassing and deals with every scenario that might be applicable should you be in a different country. Therefore, should you enroll the minor child into a school, let's say, for example, in New Zealand, and they ask you, where is the father's consent to enroll the child? And you show them a court order stipulating that only your consent is required. The same may apply for a medical operation. For traveling, let's say from New Zealand, you decide, no man, from New Zealand I would like to now move to the United States or to Canada. Same problem you had initially will no longer be there because you have a court order stipulating that you do not require anyone else's consent other than yours. I hope that answers your specific question. Let's move on to the Facebook Live questions. We have a few. I had the word Facebook early on here, so let's deal with this. Question 1. Okay. I did not include the G, I see. The first question we have is as follows. What if he doesn't pay at all and he's working? No, that's a different ball game. The law makes it a criminal offense for someone not to pay child maintenance, at least if there is no court order in place. If there is no court, sorry, at least if there is a court order in place, you're in contempt of court. You're committing a criminal offense. If there is no court order in place, my advice to you is immediately approach a maintenance court. That's what you do. Approach a maintenance court immediately and ask the maintenance court for a maintenance order, and they will do that. At the end of the process, you will leave with a maintenance order. And if he violates that specific maintenance order, he's committing a criminal offense. So the question is, what if he doesn't pay at all and is working? You as a primary caregiver need to approach the court. They will either enforce a maintenance order, like open up a docket against him, or what they can do, get a garnish order or attach his salary, sell his car, sell his house, whatever the case may be. There's quite a few processes that can be done, but at the end of the day, you should not lay down and do nothing about it. You should, enforce the maintenance order. As I mentioned earlier on, if there's no maintenance order in place, you should obtain a maintenance order. I hope that answers question number 1. Okay, the formatting is not so nice today. Question number 2, let's copy and paste that one. If you want me to add on to any question which you have posed, message us on Facebook Live and say addition to question number 1 or question number 2 and so on. Okay, question number 2. When he was unemployed and not supported by parents, but my family had to stand in. Okay, so the law expects family to assist when it comes to child maintenance, but at the same time we expect both families to come in and assist in child maintenance. Therefore, if the father is unemployed, then his parents can be approached to assist in paying his maintenance or part of his maintenance on his behalf. And the same way the mother, if she is caring for the minor child, then her family can come in and assist as well. So if he's unemployed and his parents can afford to assist in paying of the child maintenance, you can approach the maintenance court and ask the maintenance court to have his maintenance be paid for by his parents. So that is possible. I hope that answers your question. I do not want to add too much comment. That's all that I have from you. You're welcome to pose an additional question to that question. Okay, so, oops, question 3, oops. The third question on Facebook Live. What if the maintenance are not used for the child but for the one party's parents' debts? Please advise. And obviously you're paying too much maintenance because the maintenance gets used for food, clothing, accommodation, and so on. So if the parent obviously is providing the child with accommodation, obviously the parent is feeding the child and buying the child clothes, and whatever is left at the end of the month, she's using for her own debts or parents' debts, of course, and you are paying too much child maintenance, and you should make an application for reduction of child maintenance. What sometimes happens is, I'm not saying this is a specific, applies to this specific scenario. Parents, for example, pay 1,000 and maintenance, I'm using a silly figure here, and that money goes to paying someone else's debts. But at the end of the day, the child does get fed, the child does have accommodation, the child gets transported to school, and so on. So maybe the cash that gets paid is not used directly for the child maintenance, but indirectly the child is being paid um, for his or her expenditure. But if you are convinced and you believe that I'm paying 1,000 rand maintenance per month, 500 rand gets used for the child's food, clothes, etc., but the other 500 rand gets used to pay someone else's debt. Obviously, you're paying more maintenance than you should be paying. Then, under those circumstances, you should apply to court for a reduction in child maintenance. I hope that answered your specific question. The third question on Facebook Live. I'm having a quick look at Facebook Live, and I see no further questions. So for those people who have posed questions now, thank you very much. Thank you for all your always logging in and joining in and posing questions, and I hope you have a wonderful weekend, and I'll see you online again soon. Have a lovely day.